Good morning, everyone. Today is Wednesday, 10 a.m. Mountain Daylight Time, and that means that we are back again with another episode of the Canadian Immigration Live Q&A. Today is just the two of us. Mark is away, so it's just Alicia and I. And while we're waiting for people to pile in and leave us a comment, letting us know where they tuned in from, Alicia, how are you doing?
I'm doing okay, Igor. It's interesting times in Alberta right now. We've got drought in the north and we've got floods in the south, and I think there were frost warnings last night. It is such a strange summer, and yeah, things are very, very wet. There's been lots of flooding here, and that's been keeping us busy. We had yeah, one of our family members had a flood in their basement, so trying to manage that, but yeah, it's not a ton going on in immigration right now. It's a little bit quiet, I think, for the summer. People are kind of trucking on as normal. There has, of course, been a round of invitations, so we'll definitely talk about that today because hopefully some of our listeners are among the lucky invitees under that healthcare round of invitations. Other than that, we can go over the ground rules, maybe, Igor, about what we do, why we're doing it, who we are.
Mm-hmm. Yeah, so we are Canadian immigration lawyers. We are based in Alberta, but we serve clients all around the world and assist with all types of immigration matters except for refugee cases. Um, and for those people who cannot afford to hire our firm, we do these live Q&As where we try to provide as much valuable information for free, or we have developed a series of different DIY courses where you can complete your application following our guidance and instructions. And if you're interested in that, you can always go to our website at Canadian Immigration Institute, and there you will see our available courses. And if you need just a little more help with your individual situation, you can always book a consult with us, and that will be the first step, whether you want to just ask a couple of questions or you want to retain our firm and represent you through our collaborative review model. So that's in general what we do for those people who are new to this channel. If you're not yet subscribed, please do. And as part of our effort to provide as much valuable information for free, we do these live Q&As, and we encourage that you leave a comment letting us know what is your question, and if your question is more generic in nature, we'll try to answer that.
hmm Yep, so we'll definitely try to answer as many questions. We'll provide as much immigration information as we can, but just like Igor said, if you need advice, that's what we're here to do, but you need to book a paid consult because it's just not professional for us to try to give you individual advice on a few lines in a chat or a YouTube video. So we definitely need to know way more about your circumstances and where you've come from, what your options are, what your work history has been, education, all sorts of things like that before we can actually give you targeted immigration advice. And we're going to be honest. We're going to tell you things that you may not want to hear based on our honest assessment of what your chances are. So we will definitely give you the straight goods. And we'll let you know what we think about your application or your chances.
Mm-hmm. Yeah, and so we'll probably now touch on one more thing, Alicia. So just recently, you've released a blog post, and so I want to share this blog post with everyone, and perhaps you can talk a little bit about it before we jump into the questions.
And so Mark and I recorded a podcast. I don't think it's actually been released yet, but we talked about LMIAs and whether LMIAs are still possible in 2025, what's going on with LMIAs. And so I spent a bunch of time last week writing this blog post to summarize the key things that have been happening with LMIAs. And so we have a few articles, and if you scroll down on this one, Igor, it's pretty long. So I've hyperlinked our other articles. Mark wrote one, Igor wrote one, I wrote one about arranged employment. We're talking about, okay, what is going on with LMIAs? And there's a lot of confusion it is still technically possible depending on what kind of labor market impact assessment the company is trying to go for. And so I wrote this article for employers, but also for employees to understand that this is a really difficult process for employers, and especially if you're looking at a low wage LMIA. So I'm explaining in this article, I give a little scenario analysis of how to understand, because there's also a lot of confusion about how do I even figure out what a low wage versus a high wage LMIA is. Most people are using the wrong figures. So determining that cutoff, and then there are really strict requirements now if you are in a low wage situation. So you still have the cap, employers have a cap on how many temporary foreign workers they can hire. There are refusal to process rules for any unemployment areas that have unemployment rates higher than 6%, with some minor exceptions. But it's really tough if you're in a low wage situation. There are still high wage LMIA possibilities. And one of the questions I get from employers all the time is, how long is a high wage LMIA going to take me? And this really depends on how organized you are as an employer and whether you've applied for LMIAs in the past, whether you have your account set up properly, whether you have a job bank account, how do you go through that advertising and recruitment process. There's a lot to know about that. The processing times are probably longer than people expect because you have to have all your ads concurrently running for usually 4 weeks. And then you submit the LMIA application, and then ESDC is going to take, whatever business days they say that they're going to take, plus probably a little bit extra. So you're looking at a number of months processing. So if there are LMIA questions, please take a read of that article, and please reach out, because LMIAs are not something that companies should be doing without a clear strategy and without really good legal advice and representation. So one thing to keep in mind, because it is tough for people right now. If you're an employee, if you are on a postgrad work permit and your time is coming to a close, things are really difficult in order to try to get PR. And so I don't know about you, Igor, but I've had a number of consults recently with people saying, what do I do? Do I go back home? Do I take a run at trying to do this express entry application, even though the system's counting my days of work a little bit too early? What do I do? So there's a lot going on right now for people whose time is running out.
Mm-hmm. Yeah. Okay. So on this note, Alicia, I propose that we move on to questions. Again, for those people who are watching us live, please let us know where you tune in from. If you want to ask something specific, please do that as well. Leave us a comment. We'll start with giving a shout out to a couple of our viewers. Tulipa is from Jamaica, giving us a shout out. And then I think I also saw one more from Jobayed in Toronto. Hello to you and to everyone else who are watching us live. Okay, so we'll start with the questions and we'll try to go through those in the order in which they were received. For some questions, if we skip your question, that means that we think that it might be a little too specific for us to pull it up and read the question, and just to let you know that, okay, book a consult. But we try to pull more questions than as many questions as possible. Okay, and so the first one would be from Ferencify. So I'm a single applicant expecting permanent residence in 4 months and planning on getting married then. Can my spouse work in Canada on a spousal visa, and how much time she would take to get her own permanent resident? And there are many, many questions that we want to ask before we can give you an answer.
Yeah.
Alicia, do you
So
want to tackle
Frenchify.
this?
Yeah. So there's a number of things. So um, one of the things when you're doing an express entry or any sort of PR application, I don't know if you're doing express entry or if you're doing a different stream, is, do you meet the requirements of a common law relationship? So have you been living with this person when you're continuous cohabitation, or are you just dating and you're not living in the same places? Because if you are common law partners, then you have an obligation to notify IRCC that under Canadian law, you would be considered already spouses. And that makes a difference in terms of your points calculation and potentially in terms of settlement funds. So, are you common law partners is one question. Did you disclose that? Have you been in a relationship for a long time? What's the nationality of the person that you intend to marry? The other thing is, if you don't have to disclose them because you've just been dating and you're not common law partners and you're not legally married, then okay. Once you get your permanent residency, then usually you as the permanent resident, the Canadian permanent resident, would then sponsor your spouse if you are legally married. That's normally what would happen. Sometimes it's possible that if your spouse has a very strong human capital, or maybe they speak French and maybe they can create their own express entry application, maybe they would want to just try on their own if they think they have a high CRS score and they think they have a good likelihood of getting express entry. So those are things to think about. It is sometimes possible, so depending on whether you filed a spousal sponsorship or not filed a spousal sponsorship, it is sometimes possible for the spouse to apply to come as a visitor. But most of the time, um, you've got to do an analysis of what is the temporary intent. And if you don't have temporary intent, if that spouse is just going to come to Canada and really wants to stay here forever, then that can be a problem and that can lead to visa applications getting refused. So it's often important to be really honest with immigration and say, yes, we have a dual intent. I'm looking at sponsoring my spouse. In the meantime, I'd like for them to come over and visit. If you want your spouse to work, this is usually a much more difficult thing, right? Because you have to meet the requirements for who can come over on a spousal open work permit. And normally that is not somebody who's simply married to a Canadian permanent resident. So we would want to know much more about your situation before we could give you some advice, but those are some of the questions that we would be thinking about when we look at this scenario.
Mm-hmm. But in general, yes, your spouse can work if she, he, whatever, has a work permit, right?
Mm-hmm.
And so there's an exception that allows to apply for the work permit from inside Canada as long as your spouse is inside Canada, regardless of whether you applied for outland or inland spousal sponsorship. But it's a long-term immigration strategy, and it's not a slam dunk, right? Like you don't just submit an application and then all of a sudden apply for the work permit. So there are some steps that you need to take, and each step must be successful before you can reach this immigration goal.
Yeah, and normally you have to have already had a visitor visa, and then
Mm-hmm.
you have to file the spousal, then you have to have AOR, and then you can submit that if you're living in the same residence. So there's a bunch of things to look at.
Yeah, and you can take a look at this webpage on RCC website that will guide you a little more. Okay, and if you need any help, again, you would go to our website at Holthe Immigration Law, holthelaw.com, and then you would click Speak to a Lawyer and select with whom you would want to book a consult, and then we can guide you a little bit more, taking into account the specifics of your individual situation. Okay, so the next one would be from Rosemary. I have existed work experience. I'm not exactly sure what Rosemary wanted to say there. I haven't mentioned in my applications with RCC. Okay, can I bring it up for a federal skilled worker program? And lots of red flags start to appear, especially given that we just recently worked with someone who had work experience that they claimed points for in their federal skilled worker application, and they've disclosed that work experience in their previous 3 applications, but forgot to include that work experience in 5 applications ago. So RCC dug that up, and then the RCC said, you know what? You didn't mention that work experience. But the problem was that RCC could say that, right? Like there could be some suspicion, and RCC would need to give the procedural fairness letter to that person, which they didn't. And so we ended up going to federal courts. Now the matter is discontinued because we just, luckily the person received an ITA, and for the next application, there will be a little more explanation before the application gets submitted, but it can be certainly a problem, right? Absolutely, it can be a
Definitely.
problem. Because every time that you submit an application, you put a check mark saying that I confirm that everything in this application is true, complete, and accurate. And so RSSC may come and say, oh, okay, so we're thinking you're trying to misrepresent. You misrepresented in the past. Or in a good scenario, they would not give you any points for that work experience and just refuse your application. So there are many, many things that can happen. Alicia, do you have any experience like dealing with people in identical situation?
Yeah, so Rosemary, it really depends on how many applications did you file? Was it material to those applications? Why didn't you disclose that previous work experience? And just like Igor was saying, IRCC has a really strong um, inclination to say that you're misrepresenting, right? If you came on a study permit and then you did an extension on your study permit or a change of conditions and then a PGWP, and only now when you're trying to apply for your express entry under FSW, magically you come up with this extra foreign work experience, they're going to be super suspicious of that extra super long ago work experience that you didn't mention on your previous 3 or 4 applications. Now, sometimes, just like Igor said, somebody disclosed it on their initial study permit. They didn't realize they had to disclose it on the next application because they thought they already had. Maybe they have an explanation for that. It also depends on how strong your evidence is that you actually did that job in your home country. Do you have tax documents? Do you have letters from that employer? Are they a large reputable company? Do they have a website? Do they, is your manager still working at that company? Do you have pay stubs? To prove that you work the hours and the type of job? Do you have a job description? So all these things are really important, but understand that if you fail to disclose it in the past, there definitely is a risk on trying to rely on it now for points for federal skilled worker, for foreign work experience. So you've got to weigh that risk. Um, of course, you have an obligation to be honest and correct immigration's record to say, yes, I actually did do this job. There are some circumstances where people hid doing a job because they didn't think they'd get the study permit, and that's why they didn't disclose it. And that can
Mhm.
definitely be a problem.
And maybe a little pro tip. It's always better when you come forward with this first rather than waiting for the officer to find it out and then just refuse your application. So if you know that you missed something in your previous applications, address it before the officer finds it out. Um, Try to explain it beforehand. Okay, so be upfront with everything in your application, and that perhaps can work in your favor. Okay, so the next question would be from Anthony, and for Anthony, we're gonna give applause. Congratulations on eCooper, and thank you so much for mentioning the Express Entry Accelerator course. And again, what Anthony is talking about is our Canadian Immigration Institute website and the Express Entry Accelerator with the bi-weekly master classes. So the next one will be in 2 weeks. Mark had just a master class yesterday, and you have over 10 hours of video content with step-by-step instructions, sample documents, templates, different tools, and worksheets that will help you prepare a better Express Entry application and avoid most common mistakes. So for Anthony, that worked, and we're super happy to hear that now you have an e-Cooper. But Anthony asks one more question. So if my son's e-Cooper, in my son's e-Cooper, RCC put his old passport number. However, I have submitted the new passport at the time of Portal 1. Do we have to get that corrected? And so my understanding is that Anthony's son is already in Canada, so they have been landed as permanent residents. And as long as the e-Cooper was issued while the person is in Canada, then I don't see any issue with that. That would be a little bit different if that wasn't an e-Cooper and you had to travel and you had
Mhm.
to present a document showing the passport number for the passport that is now expired. So it's I don't think that should be a big problem. Alicia, do you think otherwise?
Yeah, so Anthony, I mean, it sounds like you did the right thing. You submitted the new passport at the time that you were doing the portal so that you confirmed that this is the most accurate, up-to-date information. It seems like they still issued the e-Cooper with your son's old passport number, even though you had already corrected it at the time of Portal 1. Um, Technically, when you're getting that e-Cooper, you usually have an opportunity to tell the officer of any changes and then they can make an update. But of course, when it's an e-Cooper, you don't have a chance to talk with anybody. They just digitally sign it and send it to you. But just like Igor said, if your son's not traveling on that passport, if they're already in Canada with you and already landed as a permanent resident, hopefully it ought not to affect anything because he's already here and you had already corrected that information in immigration system. So as long as they're physically here, hopefully it ought not to be an issue. If they had to travel, you might have an issue to confirm the passport or update that e-copert with the new passport information.
Okay. We will break the sequence of the questions a little bit because we've received a super chat from Isabella. So she's asking, I got an invitation from Tech Pathway under AIP. Congratulations again. But I'm still wishing to receive an ITA through the CEC with my score at 519. Can I have both applications going at the same time? Any pros or cons that I should consider?
So, yeah, I mean, you can definitely have both applications going. So right now you're at the expression of interest stage and you have to decide whether you're going to actually finalize that AAIP application. If you do, I mean, you might as well. There's just the application processing fee that you've got to pay and the time of going through and preparing that application for AAIP. You've got to make sure if you keep that express entry application also going, and you would need to if you're looking at tech, then make sure that both of those applications are concording, right? That everything that you have in your express entry application is matching what you're putting in your AAIP application. Sometimes AAIP asks questions a little bit differently in terms of your background and personal history and things like that. So you've got to make sure that both things are correct. You've got your primary occupation picked correctly. You've got your work history listed correctly. At a certain stage, you might get that nomination from Alberta. Maybe you can take a look at the processing times. They're pretty long right now. And in the meantime, maybe you just get a straight CEC draw. It's tough with that 519, right? We just had a CEC at 518, so I'm not sure how long ago you created your express entry profile and when you actually hit the 519 points. So yes, you can have both applications going. You just have to make sure that they're both 100% correct, that they match, that there's not discrepancies between the two applications. And theoretically, if you got a federal invitation to apply, you'd probably go with that one because it's going to be shorter processing times. But if you have both horses in the race at the same time, eventually IRCC will ask you to decide on which one you're going to do. It would be unlikely just because if you got an ITA, then your profile is locked. So you probably wouldn't be able then to get the nomination to get the 600 points under your express entry profile. So you can keep both applications in the queue until such time as you actually have to make a decision, basically.
Okay. And Alicia, we have so many good questions. So I will move on to the next one from Franklin. Is flight training considered a post-secondary education if completed from a flight school?
Oh, Franklin, flight training is tricky. It's one of those ones that's a weird creature. So there's a few things to consider. I'm not sure in what context you're asking this question. So generally, you have an obligation to tell IRCC of all your sometimes secondary, but definitely post-secondary education. And sometimes you have to tell the PNPs or the provinces about your secondary education as well. So take a look at what exactly the question is asking. If you have to talk about your personal history, you definitely want to disclose, I was going to flight school from this time to this time. In terms of whether you need a study permit, that's a whole other question. You've got to go through and see whether your flight school is actually a designated learning institution. Some of them are and some of them are not. And so you'll have to go through the list of IRCC's designated learning institutions list and see if your flight school is actually listed. So in general, you're going to disclose that you did do flight training. If you needed a study permit for that period of training, that's where you're going to make sure that you did apply for a study permit if it was required and it was a DLI. So Igor's
Would,
sharing a helpful page on flight schools.
yeah, I would recommend just search for flight training education IRCC, and then it will take you to flight school, and then you can take a look at the list of regulated flight schools. So here.
Yeah.
Perfect. Okay, let's move on to the next question. So are there any opportunities for retirees to immigrate to Canada with their family? The short answer is yes. There are always opportunities, but really, the opportunities that you will have really depend on your individual factors. I remember I had a consult with an elderly person from the U.S. A couple of months ago, actually. Um, I think I think that person was like 75 years old, Alicia, and the person was seeking to immigrate to Canada as a permanent resident through an economic immigration program. And so my initial feeling was like, there's no way, like this person would lose all of their points for age. There is no Canadian work experience. There's not a single chance for the work permit. But then guess what, Alicia? This candidate spoke fluent French and English, and had work experience in the medical industry. And then all of a sudden, his score was like above 500. And I'm like, seriously? Like, we have
Yeah.
so many young candidates who come to Canada and study here and complete their master's degree, and then speak fluent English, and then have Canadian work experience and foreign work experience. And they still cannot get an ITA. But this guy, oh, and on top of that, Alicia, he had a PhD. And I'm like,
Yeah.
you're a perfect candidate.
Yeah.
So it is possible. It is possible for sure. But how possible it is, that really depends.
Yeah, and it is interesting, global biz life. I had a consult with a doctor last week as well, and it is tough if you are, because anything over age 45, you lose all your age points, right? You get 0 points for age. And so this is where you've got to have the education points to make up the difference, perfect English, probably some French in order to get you over that CRS cutoff, and probably some experience in a targeted category-based thing like healthcare, because that's the one that is being drawn more. Well, we just had a big draw, which was nice.
Mm-hmm.
So, depending on what specific makeup you have, you may or may not have a chance at an economic category. The other one would be things like the um, Atlantic Immigration Program. We've got the Rural Communities Program. If you actually can get a job offer from a designated employer in one of those communities, Francophone communities pilot program as well. So if actually somebody has a job offer from an employer in one of those more rural categories, that could be something. There isn't kind of this investor class ability to come and just deposit a bunch of money in Canada and come under that basis. They've largely gotten rid of any of like the programs that used to operate on that kind of function, like an owner operator LMIA or some of the startup visa kind of programs. They've been trying to scale things back and try to sunset them because of fraud in the system. And so there are some PNPs that have entrepreneur programs. For Alberta, you basically have to have been a grad or have be operating a farm in order to look at most of those entrepreneur pathways, but it does depend on province. So if there are no permanent resident options, sometimes people have a Canadian child or grandchild, and then they look at doing a super visa application, which doesn't allow you to work. But if you don't need to work and you're retired and you have your own private healthcare insurance, then maybe you just come here and you can stay under super visas as a visitor for 5 years at a time, and it's a 10-year visa duration.
Mm-hmm. And then for our US based clients, the first question that we ask is, what is your heritage? Do you have anyone who was a Canadian citizen who was born in Canada at any time in the past? And then if the answer is yes, then we potentially consider, is this person already a Canadian citizen? They just need to prove it, and they need to apply for the citizenship certificate. So it really depends on your individual circumstances. And again, if you want to discuss those circumstances and probably make an assessment of potential pathways for you or the steps that you need to take, please book a consult. You will find the link in the description below the video. Okay, the next one is from Lillian. Do university teaching assistants fall under the education category for express entry category-based draws. And so here, Alicia, I will share my screen and we'll show Lillian the list, the very narrow list, I'll say the least, of eligible occupations for the education category. And as you can see, university teachers are not on the list. Alicia, do you have any idea why they're not on the list?
So this is where immigration consults with industry, they consult with stakeholders, and they decide, all right, what are the target occupations? What are the chronic shortages that the provinces and various economic regions are facing? And then out of that, they will come up with our targeted list. We were all pretty surprised when education was on here at all, but it is. And so they wanted to be pretty darn targeted with who they wanted to bring in. And so there are only 1, 2, 3, 4, 5 occupations, national occupation codes that are on this list. It can change, but they only change it yearly. So we'll have to see if this targeted occupation list, if it remains in terms of educators for 2026 or if it is expanded or modified. So teaching assistants in terms of university teaching assistants are not on the list. One of the things that university teaching assistants, postgrads and postdoctoral fellows, normally those are under the LMIA exempt rules under various international agreements. And so I do have a number of clients who are teaching assistants or who are working here under LMIA exemptions for postdocs or postgrads. So sometimes people who are here on work permits and they are hoping, I guess, that their employers will either continue to support them, maybe they can gain more Canadian education that way and then qualify for express entry. But they're not on the targeted occupations. It doesn't mean that you're ineligible or not able to use that work experience for the purposes of an express entry draw. But it does mean that you would have to fit a general category, just like CEC or FSW, and get a draw based on overall points. So the benefit of the targeted draw is if you already meet CEC or FSW eligibility and you have 6 months within the last 3 years in one of these targeted occupations, then you could get drawn in a smaller pool in a category-based round, which gives you an advantage because maybe, Igor, you can flip over to the rounds of invitations and we can just see that, the CRS points have been much higher generally for a CEC general draw, whereas the educators, what are we at here, 479
Or so,
in terms of the last rounds of invitations. So
yeah, okay. And Alicia, we'll probably have to move on to the next questions, and we'll try to spend less time answering each question because we have just so many good questions today. Some days like we would connect for the live Q&A, and then we have to find those questions. Like sometimes you just like you don't have too many questions to choose from. But today we have amazing questions. So thank you everyone for posting those. So Caleb is asking, if I come to Canada as a student, can I apply for permanent residence? Of course, as long as you're eligible. But how? Like through what program? We don't know.
yeah, and Caleb, the big thing is, can you show temporary intent when you're making that study permit application? So immigration understands that people will have a dual intent under Section 22 of the Immigration and Refugee Protection Act. Take a look. We've got a number of articles on our blog about the top reasons that study permits are refused. But if you're looking at a PR pathway, be really specific in what kind of program you're choosing. It is almost impossible to qualify for permanent residence if you're only doing a one-year program. It is so difficult. So make sure you are looking at a 2-year program. It has become much more competitive in terms of how many people get study permits because we have allocations and then we have provincial attestation letters. And then out of those programs, now there's restrictions on who gets a postgrad work permit. So you want to choose your program really carefully to make sure it's PGWP eligible and that you can get a 3-year PGWP. That's going to give you the best chance and the longest period of time to try to look to gain Canadian high skilled work experience, which hopefully then is going to qualify you to get enough points under express entry.
Mm-hmm. Yeah. Okay. And just to add to this, you can apply for permanent resident at any time as long as you're admissible to Canada. before you come to Canada as a student, after you finish your program, after you leave Canada at any time, but you just need to meet the eligibility criteria, and the landscape changes all the time. So for those people who were sold this promise that you come to Canada as a student and study at any program, and then all of a sudden you become permanent resident, and that dream was being sold like for at least several years and attracted millions of students to Canada. Now they find themselves without any pathway. So it always takes a lot of careful planning and trying to predict the future with a crystal ball. Okay, so we have a super chat from Venkata, and Venkata is saying the following. So I've received my ITA on July 9th, and I'm down by 20 hours by the deadline date on the 60th date. Should I reject my ITA? My CRS score is 528. Ooh, that's a tough one. So typically what I understand is that the system rounded up the work experience for Venkata. And we would, if that happens, we would typically wait until we hit the actual number of hours or weeks of work, um, or like calendarly a year, right, before we submit an EAPR. But for Venkata, he does not have enough time to accumulate that work experience that was rounded up. So should he reject an ITA? Should we
So,
say yes or no? Probably not. We would not say that because that would be legal advice. And
right,
in those
Venkata.
situations,
Yeah, please book a consult because there's a number of factors. So I just had a consult with somebody in almost exactly the same situation yesterday, and I wanted to see the spreadsheet of what are the hours, what are the weeks, how many weeks do you have, were there gaps in employment, what happened, what are your CRS points? Did you claim foreign work experience? Did you properly claim everything? Is there something where immigration could say misrepresentation? How long is your work permit valid? Do you have other options? Because there's always a risk if you try to take a run, especially if you're not meeting minimum eligibility criteria. So if you got drawn under CEC and you're not meeting CEC, there's a huge risk that application is going to get refused. You will have wasted time, right? If if your profile is not in the pool for that period of time, you miss the opportunity to go back into the pool to keep your space in the queue in terms of the date that you submitted your profile in case the CRS comes down and then you actually have met your CEC eligibility. So there's a number of factors we'd want to talk to you about.
mm-hmm. Yeah, and I think so. Venkata just added a follow up. Let me just pull it up. So I have all experience letter, roles and responsibilities, paychecks, and I also have mentioned it in my study permit, but the company is closed right now. There is no way for me to prove it. What should I do? Book a consult, Venkata. That's what you should do.
Yeah, because I mean, I'm now confused about whether this was a
Mm-hmm.
previous period of work because I thought maybe you were saying you were short by 20 hours on a current job and you're still working in that job. We definitely need to know more.
Mm-hmm. Yeah. Okay. So the next one will be from Nash. So are super visa applicants who are Canadian citizens or permanent residents, um, super visa applicants who are children, grandchildren. So typically, super visa is only available for parents and grandparents of Canadian citizens and permanent residents. But I assume this is a mistake, and you're not an applicant, but you're a sponsor essentially, allowed to show their last year's income as a temporary resident and apply once they become permanent resident. Can you include both parents in the same application? So yes, you can include both parents, and as long as you are a permanent resident or Canadian citizen, you can support your parents for a super visa application, as long as you can show that you have the qualifying income, and that income doesn't need to be accumulated in your status as a permanent resident. So as long as you can show that within the last year or several years, the more the better. You were making the qualifying minimum income, then you can support your parents. They always ask for the last notice of assessment and perhaps your T4s, your pay stubs, just to demonstrate that you make more than what they ask for.
Yeah, so Nash, take a look at the IRCC page on super visas, go down to the minimum necessary income requirements on how to apply, and then it'll also talk about documents you accept. And so, yeah, Igor, I'm assuming that Nash is asking the question from the standpoint of he's the child, he's looking at sponsoring his
Yeah.
parents or grandparents. Documents we accept, you'll see that they ask for your CRA notice of assessment, but you can also be showing your pay stubs. You can also show your bank account statements. You can show the accountant statements showing what your annual income is if you're self-employed, pension, other sources of income, letters from your employers. So there's lots of other things that you can use to show you're meeting those minimum income requirements. When you click on those minimum necessary income requirements, which is hyperlinked right above, that's going to take you to the table. Keep in mind that these low income cutoff tables get updated. And so that's another thing I think we mentioned in our last live stream last week is that they increase the settlement funds requirements under express entry. So keep tabs on that. But in terms of whether you can try to apply to include both parents in that super visa application, theoretically, you still have to meet the minimum income cutoff requirements for the number of people that you are looking at including. And so if you have a family, if you have a spouse and kids, you've got to include them plus you, plus your two parents. And so you have to meet more and more income requirements depending on more people that you want to try to bring in under that super visa application with that letter of invitation. The other thing is your parents have to still prove that they have temporary intent. And so if you're bringing both parents and they don't have a lot of property, they're not working, they don't have strong ties to their home country, it will be practically more difficult for IRCC to approve both parents rather than just one. So you have to make a tactical decision on, do you take the risk? Do they have strong ties to their home country?
Yeah. And again, there's no qualifier that this last notice of assessment must be issued after you became permanent resident. And like it's interesting, Alicia. Many people think that as long as the host can show that they have more money than what's in the table, they meet the LICO cutoff,
Liku,
then
yeah.
IRCC will approve this application. They say, I have, let's say, 20,000 in my bank account, and I make more than what you ask for. So the application will be approved because the bar for like the threshold for like temporary intent is a little bit lower for super visa applications, just because your parent comes like and may stay here for 5 years. But then if you actually look at the requirements, super visa is a regular temporary resident visa with some additional requirements. And so just like for every TRV, you still need to show that your parent is financially established in their home country, have employment, or maybe they make money through other means as well, like through retirement or savings, or maybe they have their business or rental property and so on. So it's not a substitute, but it's an additional requirement that you also have to meet. And it's not only about the host, it's also about the applicant himself and the applicant's financial ability, even though the host must pay for all expenses associated with the trip. Okay, so on this note, let's move on. So perhaps this one would be a comment where we direct Nana to book a consult. So no work experience in New Brunswick, but I have relatives in New Brunswick. Am I eligible? MI always triggers this sound. Test scores expire in 1 month after receiving an ITA. Do I need to renew the scores? Do I also brings this sound, which means we would ask that you go to our website and book a consult where we can look at everything in your application or in your circumstances and tell you with a little more clarity as to what are the next steps for you. Ashad is asking a wonderful question, and I'm so sorry that you have to go through this. My security screening has been pending for the last 3 years under A34. So it's a comprehensive security screening. It's been 8 years since we submitted the sponsorship application, and I received a non-favorable security screening. I'm not exactly sure what do you mean by non-favorable security screening, and what's going on behind the scenes. We don't know. Typically, this would not be normal for RCC to keep your file for pending for 8 years. And if there is some reasons why they have you in security for 3 years, we need to know there's these reasons, and perhaps you know why they keep your file. If you don't know, and there is absolutely nothing that would explain why they would keep your file for 3 years pending, for 8 years to be exact, then then it's definitely an unreasonable delay. If there is nothing, but we need to know, and sometimes we don't know only until we filed a mandamus application, and we'll learn these details from the respondent's memorandum, where they actually disclose what's going on. So,
Well, and yeah, the interesting thing, so 34A is super serious, right? It's a
mhm,
security risk for espionage against Canada. And so this is a serious type of inadmissibility. And because it's a security risk and because it's espionage, they usually will withhold the case that they have against you unless and until they actually present it in terms of some sort of charge or allegation. And so this is where this is a serious charge, and you will definitely want to be engaging a lawyer to be working with you in order to try to figure out what sort of allegation are they bringing against you, what's the evidence, because this is going to probably be a long fight.
yeah, and just as I've mentioned, likely you know what's going on. Like, if you have no idea, then it means that maybe there's a match between your name and someone else's name. Maybe there is something else that triggered their attention to your matter. And it's not okay to have a file pending for 8 years. Absolutely not okay. And so, in those circumstances, we would absolutely consider mandamus, but we need to know. And perhaps we need to speak with you before we tell you to commit and spend like thousands of dollars on a mandamus application. Okay, the next one is from Cynthia. Um, if you are an early childhood educator and also have French CLB7 for all 4 categories, which route do you suggest I use?
So, Cynthia, it depends whether you're also meeting minimum eligibility criteria for federal skilled worker or CEC. So, in general, express entry is a great option if you do meet minimum eligibility criteria. So go to the IRCC page, check to see, are you meeting your eligibility criteria? Have you been working for 1 year continuous in Canada, or in a combination of different high skilled jobs within the last 24 months? Can you get in aggregate 1 year equivalent? So you've got to get that 1,560 hours, 30 hours a week. You can't overcount for multiple jobs for 1 week. Take a look at whether you're meeting CEC. The other thing is, do you meet FSW? So do you have foreign work experience, and are you meeting the 67 points on the selection grid? And if you are, then probably creating an express entry profile, if you're eligible, is going to be a very positive step. You have to have your education credential assessment and your language tests in French and probably for English as well, and make sure that those are still valid. And then the other option is, if you happen to have a job offer from an employer in a designated community where you're looking at that Francophone Communities Pathway Program, then that might be another option for you, depending on where you're working and if you can get a job offer.
Mm-hmm. Yeah. Okay. Let's move on. So, Nana's asking again, will RCC check my previous applications before considering if I'm admissible to Canada through express entry? Will RCC check if I have left a foreign country or not during the PR application?
Yes, yes, they will.
Yeah. Okay. We'll move on to the question from Abdul. Is it okay to have monthly salary stated on the reference letter instead of an annual salary? Yes, it is okay. And you can also mention your hourly salary. Remember that um, if you cannot get the exact requirements that are listed in the express entry completeness check for the reference letter, you must satisfy the officer by other means. So let's say if The letter does not include the contact email of the person who signed the letter. You need to provide something else that would, in addition to that letter, provide the officer with this information, like a business card. If you cannot get an annual salary on the reference letter, write an hourly rate and the number of hours to work per week, which is an absolutely mandatory requirement. And then essentially you provide the officer with the tools to come to a calculation. Again, it's if possible, write whatever they ask for in the requirements. If they ask for annual, try to give them annual. If it's impossible, then give them monthly or an hourly rate. Okay. And Abdul, this is a perfect example where we would also direct you to our expert century accelerator, because we talk about this in detail there. We give you tons of different examples with reference letters from our previous clients, and we have a database, like bank of those decisions, not decisions, but reference letters, sorry. And you can take a look and see how other people structure their letters. Unsolicited intellect. Man, I love those names. I wanted to ask if, under the category draws, proof of funds are required, or it will be like CEC, where I don't have to provide proof of funds.
So, unsolicited intellect, take a look at the article that I wrote on job offer points. Also, take a look at what the requirements are for CEC versus FSW. So, you are not in control of whether immigration gives you an invitation under CEC or FSW if you're looking at a PNP program. So, it's very rare now that IRCC is issuing any invitations under FSW. They've basically all been under PNP, CEC, or one of the targeted based draws. So if you are in a circumstance where your ITA is under CEC, you don't have to prove settlement funds. However, if you are in a circumstance where you have been invited under, let's say, a PNP, then it could be possible that you have to prove settlement funds. And that's going to depend upon what the requirements were for the province and what your ITA is. If you have a job offer, so arranged employment job offer, you don't get the points, but it can exempt you from the requirement of having to prove settlement funds. So for example, if you had a category-based draw, like under the Francophone category, you might have to, in fact, prove settlement funds if you're invited under FSW under a Francophone-based draw. If you have a job offer and it qualifies as a job offer, then that can exempt you from the requirement of settlement funds. But in general, if you get an ITA under CEC, you don't have to prove settlement funds. You do have to provide an explanation. If you are invited under a category-based draw or a PNP where you do have to prove FSW settlement funds, then make sure that you have that money in your account over and above your liabilities for at least 6 months.
Mm-hmm. Okay. Hans is asking, would you recommend to disclose part-time work for postgrad work permit application? Once postgrad is granted, main applicant will sponsor for spousal open work permit. The part-time by then will be full-time in tier 1. Thank you.
Yeah, so Hans, this is, getting close to needing a consult, but in general, it is important that you disclose your work history on your postgrad work permit. And I've seen many cases where, they only give you 3 different spots in your application form when you're doing the application to change conditions on the IMM 5710. And a lot of times people just put their most recent jobs and they don't put their part-time jobs, or they don't put older jobs, and that can come back to bite you when you try to apply for a spouse's open work permit, or when you try to apply for your express entry or other PR application. So yes, it is important to list your occupations, anything for which you have earned income or salary or commission. So it's a paid employment position. Make sure that you put that on your employment history section in your PGWP, because it can really matter, especially if you're going to be relying on that work, which is then going to become full-time, which is then going to become the basis for your spouse's application. And then, yes, of course, it's got to be a tier 1. You've got all the rules under the high skilled foreign worker requirements for spouses.
Mm-hmm. Okay. Perfect. Let's move on. Alvin is asking, what is the right time to stop working once I finished my studies and transitioning into a post-grad work permit? What a wonderful question, Alicia. What a wonderful question.
Mhm.
Where can you find the answer to this?
You can find the answer right here. So, Alvin, this is a question I've been getting for years and years. So, I wrote an article on this, and it is very important that you do this properly because if you don't, it can result in a refusal on your PGWP or a delay in when you can get issued your PGWP if you are working without authorization. It's also potentially a ground for misrepresentation or a ground for not being able to claim your Canadian high skilled work experience, all of which are bad things. So the rule is pay attention to the first date that you get your letter of completion from your school, the first date you get your official transcripts or are otherwise notified that you've completed your degree, or the date you get your diploma, which is normally the last date. Um, but the earliest of those three is the trigger event, and that's the day you have to stop working 100%, no work, zero work. You can't work as a student once you've completed your program because you're no longer a student and you can't benefit from the work as a full-time student rules. So make sure that you 100% stop working when the earliest of those three things happen. You submit your PGWP. Pay attention to what day you submit your PGWP. Keep a copy of that letter that they send you saying that you completed your application on this day. And that is the first day that you would then be eligible to claim high-skilled Canadian work experience going forward.
Mm-hmm. This one is a good question. My husband applied for a closed work permit and we got only 1 year instead of 2 years because of the passport expiry. So, can we extend the work permit, get a new one, to recapture this time that was missing once they renew the passport?
Generally, yes, but you've got to do it properly, and it depends on exactly what kind of work permit. Was it a closed employer-specific work permit? Because then the employer might need to submit a new employer portal offer depending on what happened with that application. Um, is it an LMIA-based work permit? That's a little bit more tricky if it was LMIA-based. If it's an open work permit, sometimes you can't recapture. You have to get a whole new application, but
Yeah,
you just want to do it carefully.
yeah. Like NEMA specified it's a closed work permit, so definitely
Mhm.
not an open one, but again, NEMA, it's just too sketchy for us to give your instructions as to how to proceed, not knowing all the details. Um, Nana is asking one more question. If not code has only one duty, can I add more duties? You need to add all the duties that you performed in your job. And then you must satisfy the officer that this not code that you selected is the correct not code. So if the not code has just one duty, that doesn't mean that your reference letter can only include one duty. And even worse, you cannot put the duty exactly the same way as it is in the not code. Because guess what? The officer will conclude that it's not a genuine letter. You just copy pasted the duties and you did not actually perform those. You just wanted to fit in. And so you never want to end up in this situation. So absolutely, you need to include all the duties and responsibilities that you had in this
Yeah,
particular title.
and then I think you were saying you were a research assistant or a teaching assistant in university, and this is a difficult knock. I've had many clients who are in this knock. Take a look not only at the bullet points, but also at the opening paragraph, the lead statement. So you need to show that you're doing the activities of the lead statement as well as the bullet points. Um, and just like Igor is saying, you have to satisfy that you're meeting the mandatory main duties plus the activities of the lead statement. And then if you have other related job duties, you're definitely going to list those. Take a look at our course or please book a consult and we can walk you through this.
Absolutely. The next question is from Ali. Can I use Tier 4 experience for permanent residence? Ali, the world of permanent residence is a west world. Like you cannot understand exactly what pathway to permanent residence you're talking about just if you mention permanent residence, because we have federal economic immigration programs, we have provincial economic immigration programs, we have family immigration, and many other pathways to permanent residence. And so while for federal economic immigration program, you need to have skilled work experience, for some provincial economic immigration programs, they don't limit your qualifying work experience in Canada um, to only tier 0, 1, 2, or 3. You can also use tier 4 or 5 sometimes, and that really depends on the province. So what exactly pathway you're asking about, we don't know. But for federal economic immigration programs, it must be skilled, so tier 0, 1, 2, 3. For some provincial nomination programs, it can be tier 4 and 5. And for some other economic immigration programs like rural community immigration pilot, you can also use low skilled work experience. But there are so many other moving parts to this. So in general, yes, you can, but not for all programs.
And it's so much harder. Yeah, the
Mm-hmm.
number of slots that they give for a tier 4 or 5 are so small. So it is a huge uphill battle if you don't have the high skilled, which is tier 0, 1, 2, or 3.
Yeah. Okay. Hammond is asking, can I do an upfront medical exam for super visa? You cannot. You must do an upfront medical exam for super visa. So if you go to super visa requirements, let me just find them real quick. Super visa medical exam, um, and then let's see. I'm just going to pull up uh, this page. Who needs a medical exam? Okay, and I'm gonna share my screen. So, um, okay, you need a medical exam if at least one of these applies to you. You're applying for parent grandparent super visa. Plain and simple. You must do it. You cannot. You don't have an option. Should I do it? Should I not? Okay.
So Hemant, for super visas, you've got to show that your parent or grandparent is medically admissible, and also you've got to make sure that you get private healthcare insurance that follows all the rules. It has to have, the number of specified amount of coverage, plus it has to have cover repatriation. Um, in addition to the fact that you've got to show that your parent is going to be medically admissible. And so upfront medical required, healthcare insurance absolutely required, and then LECO and proof of temporary intent and all of that.
Mm-hmm. Okay. A couple more questions before we wrap this up. Simon is asking, for those of us with citizenship background and prohibitions pending for over a year and a half, what recommended way would you suggest? That really depends on the individual circumstances. For some people, just a year and a half of delay, um, maybe that's the only delay that they experience. For some people, they experience 5 years having their applications pending. The processing times, they fluctuate all the time. We see delays across the board in all immigration applications. And again, we just need to know exactly what's going on. If we ordered the GCMS notes and we see that the last time they actually touched your file was like a year and a half ago, then yes, like there's something going on. They just put your file in a long drawer, and we need to do something to compel them to make a decision.
Yeah. Unless you actually do have a prohibition, right? So if
Mm-hmm.
you have a prohibition and you are not eligible for landing as a citizen or for citizenship grant, rather, because you have bankruptcy, because you have a criminal charge or conviction for one of the reasons, because you're prohibited from getting citizenship because of some other um, problem, then definitely if it's your issue that's preventing them from finalizing the case, then we would not do a mandamus
Mm-hmm.
application because you have to come with clean hands.
Yeah, yeah. There is a test that the court considers whether to find a delay unreasonable, right, and whether to grant mandamus or not. And one of the steps in this test is that the applicant have not contributed to a delay. So perhaps there's something that maybe RCC sent you a request and you took your time to respond to it. Like we don't know. Okay, so um, it really depends on the circumstances. It's not like this question where we can give one answer that would fit all. Okay, we have one super chat from Eliza. If there's a status restoration of status in process, but my husband can give me an open work permit. So I assume Alicia can apply for the spousal open work permit because of her spouse, theoretically. Can apply for it, trying to get this one faster. Restoration of status is tricky.
Yeah, Elisa, we would say book a consult because these are super complex cases. If you've got a restoration already in progress, um, there's problems with trying to tack on another application if you don't already have status, because if you're inside Canada, normally you can only be eligible to apply for a work permit inside Canada if you already have a work permit. But if you've already lost your ability to work and you're in a restoration period, that is a really tricky time. So you've got to be super careful, because sometimes it means that you have to leave Canada. But if you leave Canada, then your restoration application is normally canceled and you would lose that implied ability to continue to work if you're currently working. Then you'd have to make a new application and come back in. But you want to make sure that there's no risk, or you want to minimize your risk when you're going through all this. So definitely, I cannot give you an answer on this. I would need to know way more about your situation.
Mm-hmm. Yeah. And Alicia, people just don't want to let us go. So we have one more super chat from Subin. I have 2 years, 10 months, 23 days of foreign work experience, created an expert century profile, and got points for 3 years. Should I accept an ITA if I receive one? The answer to your question lies in the question itself. I have 2 years, not less than 3 years, but I got points for 3 years. Should I accept it or not?
Yeah, yeah. So Subin, um, yes, you have to have everything correctly listed in the questionnaire that you do when you create your Express Entry profile, and you've got to have your start dates and end dates properly listed in your foreign work history. Yes, for sure, it's only asking the months and not the days, and this is where all the problem comes from. But it's up to you. If you know that you're not meeting the points that you're being given in your ITA, then it's up to you to decline that ITA, go back into the pool, wait till you hit your actual 3 years before you continue on. Otherwise, IRCC could say that you're taking advantage of the fact that you know that you ought not to have hit that 3 year mark. You hit the 2 year mark, but not the 3 year mark. So be super careful. The date of the ITA matters compared to, do you actually have the 3 years by the time that you've hit that ITA?
Mm-hmm. Okay. And Alicia, we'll wrap this up because Ali's asking this question several times. But I would really appreciate if you can share with us any predictions about the French draw. My CRS is 485. Should I be worried? And Ali, all we can do is go back to the historical page with the draws and take a look at the CRS scores for the Francophone draws. You can see the scores really fluctuate depending on how many invitations they issue. And we probably should purchase this physical crystal ball and have it in all three of our locations, in Alicia's home, in my home, and we'll pull up this crystal ball, look into it, and say, okay, next time they will do 10,000 invitations or 1,000 invitations. There's no way we can predict how many invitations they will issue. But regardless, even if they issue 1,000 invitations or even 800 invitations, the score is less than what you have. So my guess is then yes, you do have a shot. How fast, how soon they will do a French draw, we don't know. They went absolutely bananas on Francophone draws. They've been doing those like every 2 weeks, every 3 weeks, every month. And then now we don't have any draw since March, so like for 4 months. So absolutely, the score will go up significantly, especially if they issue less than 1,000 invitations the next time. So it's possible that you may get an ITA, but not in the next draw, but like in the next several draws. I would anticipate that yes, you would get one. Alicia, do you have anything else to add here?
Francophone categories are super strong, right? So the fact that if you're hitting your NCLC level 7s, that gives you a huge leg up. So keep at it. See if you can, maybe there's a couple of places where you can gain some more points if maybe you didn't completely max out on English, for example. If you're working in Canada, if you can continue working in a foreign job, if you're working in a foreign job, try to get every point you can. If you have a spouse and that spouse doesn't have as high of language points, make sure that they retest and try to do their exams again as well. But hopefully with a French, you've got a better chance than most.
Mm-hmm. Yeah. Okay. One last question. Okay, let's round it up when we'll finish at 11:20. So Hammond is following up on his question about upfront medicals. How can I do an upfront medical if I don't have a request? So who needs a medical? Da, 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 da. Essentially, the long story short, you find a panel physician that is authorized by RCC. So here's the list. You must see a doctor on the list of panel physicians. So let's assume you are in Ukraine and you have the list of panel physicians who are authorized to complete the medical exams. And then you give them a call and you say, I want to do an upfront medical exam. And they will tell you exactly what you need to do. Sometimes you would go to their website, sometimes you would send them an email. So that really depends. So just go find a panel physician on RCC website and reach out to them.
Yeah, Herman, there's also a immigration medical handbook, and so you can take a look at that. But it's curious that they're asking you for the IME letter because there's two different ways, right? Either you have the request letter from IRCC or you tell them I want the upfront medical and they do the 1017B form and they just know that that's the procedure to follow if you are asking for an upfront medical. So it might just be that that hospital is unfamiliar with the upfront medical process. You might just try to contact a different panel physician, but you can also look up the IRCC manual and you can show it to them. They should be able to access it if they are panel physicians.
Okay, and we have one last minute, so I'll pull up one more question. I'm an international student in the US with a student loan and mortgage. Would that impact my federal skilled worker process? Regardless of points and having 25,000 in my brokerage account plus $10,000 in savings. Who? Lots of moving
Yes.
parts here.
Yeah, so Precious, IRCC, when they're looking at settlement funds, it has to be assets over and above liabilities. So they will definitely look, and so especially with my US-based clients, I have large spreadsheets and templates that I've built out in terms of explanation letters for proof of funds and settlement funds. You've got to go through and show what are your student loans, what are the mortgages, how much are you servicing in terms of debt, what's the overall amount, and then try to break it down in terms of monthly amounts. And then you still have to show that you have the settlement funds for you plus the number of people in your family unit in order to meet eligibility requirements under express entry. So this can get pretty complex depending on how much you have in student loans and mortgages, how you're servicing that debt, and then what kind of accounts you are holding your assets in and whether they are accessible funds.
Mm-hmm. And it's not like they take the amount that you have in your mortgage, like $200,000, and they subtract that from your $25,000 in savings. It's not like that. It's essentially you need to show the officer that you have funds to sustain yourself at least for the first 6 months after you land in Canada. And so you would need to show them that on average I pay this much a month, and so over the course of 6 months I'm going to be paying this much, and if I subtract this amount that I will be paying in the next 6 months from my savings, I'm still above the minimum threshold. And another thing is, you only have $10,000 in savings account, and that's a big problem because the funds must be readily available and fluid and liquid funds. You must be able to go to the store tomorrow and spend all of that money, and you cannot do that. You cannot pay with your stocks in the store, right? So be careful with this. Again, we would recommend that you either subscribe to the Expert-Centric course where we talk about this in detail, or you reach out to us and we can guide you a little bit more. Okay, so just 1 minute in overtime, actually 21 minutes, but we decided to round it up. We always go a little beyond. Um, the end time for our live Q&As. On this note, we will end this episode. We will see you next week again, Wednesday at 10 a.m. Mountain Daylight Time. It's very likely that we will have all three of us next week. Double check our calendars. Nope, Mark will not be there. He has a personal event in the Holthe household. So it will be just me and Alicia again tomorrow. Not tomorrow, next week. So prepare your best questions, and we'll see you then.